Good afternoon, everyone, and welcome to today's webinar, which is our first of the year, Immigration Law Review of the Year, Key Cases, and Rule Changes from 2024 with Adam Pipe from No.8 Chambers. Adam is a barrister specialising in immigration, asylum, and human rights law, and is ranked by Chambers and Partners for immigration law in the Midlands. Adam also provides regular updates on the law at training events and on social media. For those who haven't joined the webinars before, my name is Finn and I'm a Junior Compliance Officer at DG Legal. The slides from today's presentation will be sent over tomorrow and a recording of the webinar will be available for 3 months. So if we run over or you need to leave, something like that, you'll be able to watch it at a time of your choosing. We won't be answering any questions, I'm afraid, today, so please do not use the Q&A function. This is so we don't run over our allocated time, so we get it done within the hour. That's all from me. Over to you, Adam.
Brilliant. Thank you so much, Finn. And thank you for everyone who's joined us today. I think we've had nearly 900 people register for the webinar today. So that's fantastic. I'm going to be covering a review of 2024. I'm going to do it in 3 parts. We're going to look at the rule changes. We're going to look at some significant case law from 2024. There's already been some significant cases in 2025, but we're just going to focus on 2024. And then we're going to look at some changes to the practice directions and practice statements of the tribunal. You already know who I am. If you need to click on my link to Chambers, it's there on the slides. Finn has already explained that the webinar recording and slides will be sent out. Here's the link where you can access those for the 3 months. And at DG Legal, we provide, or DG Legal provide, these webinars for free. I would really encourage you, there's nearly 900 people who've registered for this webinar, to donate a couple of quid to one of DG Legal's chosen charities, because from the hundreds of us that have registered and are online now, we could make a huge difference to some really worthy causes. DG Legal don't just provide free webinars, but provide services to help law firms and practitioners in terms of compliance, like Finn has talked about, in terms of marketing, in terms of regulatory matters, if you need to get in a professional directory like the Legal 500. So I'd encourage you to go on that link about the services DG Legal offer and see how they can help you develop your practice. Now, today, there is a huge amount to get into this hour. So what I've done, I put on the screen my QR code. If you pop your camera up, you'll be able to go to a link via that QR code, or just use the link on the slide. And that will give you access to some free resources from me, some YouTube videos where I go through some of the topics we're going to talk about today in more detail. And importantly, some upcoming webinars and training events where I will go through these topics in more detail, and there'll be time for Q&A and discussion. This is just to whet your appetite and to give you a broad overview. But if you're interested in going into these subjects in more detail, perhaps you want to know more about some of the rule changes, discuss some of the case law or best practice in terms of some of the significant changes we've seen to the tribunal, I've got a couple of upcoming webinars and training events where you can sign up via that QR code to take matters further. So let's kick off by starting looking at the immigration rule changes in 2024. There were 4 statements of changes, 2 under the previous Conservative government and 2 under the current Labour government. So let's have a look at what came our way in 2024. I've given you some links to some helpful articles and summaries throughout the slide. So if you want to go through them in more detail, have a click on those links. So let's start about a year ago, actually, in February 2024, HC 556, the first statement of changes. That introduced some changes to the Ukraine schemes. So there was an announcement of the closure of the Ukraine family scheme and some changes to the Homes for Ukraine sponsorship scheme. And you'll see down the bottom of that slide a change from 36 months grant to an 18-month grant. There was also an amendment to an Appendix Ukraine scheme to apply some of the general grounds for refusal in Part 9. The previous government had already announced the closure of the Ukraine extension scheme on the 16th of May 2024, but this allowed for children born in the UK to apply after its closure. So have a look at that. And we're going to see later on some further changes and a new scheme that has been introduced by the new government. The most significant changes in HC 556, and those to draw the most publicity, were the changes in relation to care workers and senior care workers. And you've got the occupation codes there. So what did the changes do? Well, they narrowed the eligibility for sponsors in England and made it a requirement that sponsors in England had to be registered with the Care Quality Commission. There was also a removal of the provision for dependents to accompany or join workers sponsored in these occupation codes. But do be aware there were transitional arrangements, look at the bottom of this slide, for those already on this route. And that allowed them to apply to extend with the same sponsor and settle without the CQC regulation requirement. It also allowed them to be joined by dependents. So just be aware of the transitional arrangements. So that's the first of the four statement of changes. Now we're coming to the biggie. And I covered this in a spring webinar for DG Legal, which you can go back to if you want to go over in more detail. But that was the spring statement of changes on the 14th of March 2024, HC 590. And this is the statement from the then Minister, Tom Pursglove, setting out the changes. So there were big changes to the skilled worker route in HC 590. Raising the salary threshold from 26,200, which was based on the 25th percentile, to the median, which was 38,700. The going rates were also increased from the 25th percentile to the median, and that was based on the latest Office for National Statistics pay data. Although workers sponsored for health and care visas or in occupations where national pay scale rates apply, they were exempt from the new median salary requirements. They still were on the 25th percentile, but that was updated on the ONS data from 26,200 to 29,000. We also saw the shortage occupation list being removed and being replaced by a slimmed down immigration salary list following a review carried out by MAC. So this, there was still a 20% discount to the general salary threshold, but there was a removal of the 20% going rate discount. Now, we also saw some big changes in terms of the minimum income requirement, which had not gone up from 18,600 when it was first introduced. The plan was to move it in increments towards 38,700, so to bring it in line with skilled workers, with an initial increase of 29,000. And this would be a flat rate, like it's a flat rate for skilled workers, with no additional child element. Now, to bring this up to date, the new government has asked the Migration Advisory Committee, MAC, to look at this, and we should see that report in the spring. At the moment, it's held at 29,000. It's paused there. The previous government had talked about these step changes to bring it up to 38,700. Pending the MAC review, we have, at least we can advise clients that this is where it's at the moment. The rules still have the provisions, and we know exceptions in EX1A and EX1B, and in Gen 3.1 to 3.3 for exceptional circumstances. There are also transitional provisions. The spring statement of changes also brought in some changes in terms of EUSS and changes to the Appendix Victim of Domestic Abuse. That Appendix Victim of Domestic Abuse came into force at the end of January last year, and then there was an amendment in spring including partners with pre-settled status under the EUSS. They were then eligible to apply for indefinite leave under Appendix Victim of Domestic Abuse. I've already talked about the introduction of the immigration salary list. Well, that has an impact on asylum and those granted permission to work. And you'll see the highlighted section on this slide. Given the shortage occupation list's replacement with the immigration salary list, asylum seekers who are eligible and granted permission to work in the UK from the 4th of April, that's 2024, will only be able to work in roles on the immigration salary list. There was also changes in respect of administrative review in EUSS cases. The right to administrative review had been removed at the end of 2023. This also removed the provision to apply out of time for administrative review against a decision taken before the 5th of October 2023. Obviously, there's still a right of appeal in EUSS cases. On this slide, I've provided a summary from a helpful article by Lewis Silkin on the skilled worker changes. It sets out in bullet points the various changes to the salaries, thresholds, the going rates, the occupation codes, the salary list, the expansion of supplementary employment. We'll come to that in a moment. So here's the skilled worker changes and the explanatory memorandum from HC 590, and you see I've highlighted 5.3, and it says workers sponsored for health and care visas or in occupations where going rates are set using national pay scales are exempt from the new median salary requirements. Instead, a general threshold based on the 25th percentile continues to apply and is being updated from 26,200 to 29,000 based on the latest ONS pay data. Going rates are also being updated based on the latest ONS pay data and or the latest available national pay scales. And look at the final sentence. These updates also apply to skilled workers who are already in the route before the rules, these rules take effect, if they're making applications to extend their stay, change employment, or settle before the 4th of April 2030. So those are the people on the transitionals. They have to be updated from 26,200 to 29,002. This is the explanatory memorandum in part in relation to the immigration salary list. I'm not going to read that out to you. It's there if you want to look back over it. This is the consequential changes to other work routes. So that is set out there. And this aspect of the explanatory memorandum deals with the changes from SOC 2010 occupational classifications to SOC 2020. And you'll see from 5.11 that additional tables are being included for those workers who are in routes that are not on the new SOC 2020 to be able to extend their stay or settle. Have a look at 5.11. This is a summary from various articles about the changes to supplementary work. Previously, the supplementary employment must either be in the same occupation and at the same professional level as the sponsored role, or in an occupation on the shortage occupation list. An amendment was made to allow the supplementary employment in any occupation that is eligible for the skilled worker route. But obviously, employers should take care to ensure that adequate documentation is maintained for any workers carrying out supplementary employment with them. So here is a summary of the transitional arrangements for those already on the skilled worker route. And I've already highlighted that the 25th percentile is being updated from the 26,200 to 29,000. And there are the new tradable points options in the table F at 2K. So have a look at those. And actually Lewis Silkin helpfully put the table there with annotations in red, which you'll be able to go through and have a look at. So that's the skilled worker changes. As I said, there were also changes in terms of the minimum income requirement being changed to 29,000 under Appendix FM. This is where the explanatory memorandum deals with that, and 5.19 sets out clearly that there is no separate child element to the minimum income requirement. 5.20 sets out that there are transitional arrangements for those who before the 11th of April already had a family visa or had applied before the 11th of April and are being granted, and they will stay on the old 18,600, and we'll come to that in a minute. 5.21 confirms that there still is the provision for exceptional circumstances and insurmountable obstacles within Appendix FM. So this is how Appendix FM reads now, that it's a specified gross annual income of at least 29,000. There still is the provision for savings. The formula is still the same. So I've shown this slide previously. This is my maths lesson. Thank goodness I did that A-level maths. 16,000 plus 2.5 times the shortfall. So the maximum it could be is 2.5 times 29,000 is 72,500 plus your 16,000, 88,500. What about those transitional provisions? A person who has permission as a partner on the 5-year route to settlement, or as a fiance, a proposed civil partner at the date of application, must meet the financial requirement at ELTRP 3.7 if they made an application for entry clearance or permission to stay as a fiance, proposed civil partner or partner under Appendix FM before 11th of April, which was successful. Notice that it's limited to the 5-year route. So if you're already on the 5-year route, you have the transitional provisions applied to you. This doesn't apply to somebody who before the 11th of April 2024 was on the 10-year route and is now trying to switch into the 5-year route. And notice we have the 18,600 plus the child element that is set out at ELTRP 3.7, but 3.8, it is capped at 29,000. So if the number of children you have would take the financial requirement and the transitional provisions to over 29,000, it is then capped at 29,000. One of the other significant changes by the spring statement of changes was the introduction of the new Appendix Long Residence. In previous webinars I've done, most judicial ink has been spilled in trying to interpret the long residence rules. Think cases like Hock and Afzal and all of the rest of them. So we now have an Appendix Long Residence. But when you're making your applications on behalf of clients, you need to read that alongside Appendix Continuous Residence. So have both of those open before you when you're calculating if your client meets the requirements. There is a policy change for those who were granted leave last after the 11th of April 2024. They've had to have leave in their route for at least 1 year. There's also provision within Appendix Long Residence to apply for limited leave if you can't meet, obviously, the English language requirement or life in the UK. Appendix Continuous Residence was amended, and this has already caused issues, because look at the second bullet point. Those applying under Appendix Long Residence will not break their continuous residence period if, on or after 24th of November 2016, they'd left the UK with permission and returned with permission, provided they did not exceed the absence period of 180 days in any 12-month period, or 184 days at any one time if the absences were taken before the 11th of April 2024. There's no reference there to the 548 days, and the rules Appendix Continuous Residence has subsequently been amended, but I think some people would have applied at that time thinking the 548-day period had gone, and I think we'll see litigation in relation to that. There were also some changes that were brought in from June. That was a change to the definition of a parent within the immigration rules, and there's the reference to step parents has been removed. And also a consolidation and simplification of the rules in relation to adoption. So if you think about it, there are 4 kinds of adoption: Hague Convention, recognised overseas adoptions, de facto adoptions, and bringing somebody to the UK for the purpose of adoption. They're now all consolidated within Appendix Adoption. And certainly in terms of the first 2 of those, the Hague Convention and the recognised overseas adoption, see the first bullet point under 5.61, there has been a simplification of the rules and a removal of some of the previous requirements. So have a look at that. 2 down, 2 to go. Labour are in power now, and I think what we can say from these first 2 Labour statement of changes are there are no significant big changes. What we have seen, and this is beyond the scope of today's webinar, is an uptick in enforcement and removals. That's where they seem to be focusing their attention. In terms of skilled worker and sponsor license, certainly an uptake in compliance and refusals of sponsor licenses and checks, for example. So if you're advising people, those are the sort of 2 big areas where we've seen the new government focus. But let's look at their first statement of changes, HC 217 from the 10th of September last year. So an introduction of a visa requirement for Jordan, implementation of the electronic travel authorization. So one of the big themes of 2024 has been e-visas. We're not going to talk about those today. And then the introduction for non-visa nationals of the electronic travel authorization. It was opened up first for the Gulf states, and then from November 2024, opened up to all nationals who don't need a visa except Europeans, and it became a travel requirement from the 8th of January this year, 2025. And in March of this year, it's going to be extended to European nationals, and it'll become a requirement from the 2nd of April 2025. So again, for those of you immigration lawyers watching, something certainly to make sure your client base, and in terms of your online presence and your marketing, you make sure people are aware of the need and that you can assist them in getting an electronic travel authorization if they're a non-visa national. Just some other headlines: the ending of a diplomatic visa waiver and the introduction of a diplomatic visa arrangement, the introduction of the VIP delegate list. We're not going to go through those in any detail. And then a change in relation to Appendix Bereaved Partner and Appendix Gurkha was the introduction of a fee waiver for those categories, but it was the destitution test that applies in relation to that. There was also a change in relation to the EU settlement scheme and the introduction of the ability to convert automatically pre-settled status to settled status, and that started to be rolled out this year. There's the dates of implementation for you. And then we've had that change in this statement of changes to Appendix Continuous Residence in relation to long residence applications and the transitional provision. So this is what it now says: CR 2.2a, subject to CR 2.3, where the application is under Appendix Long Residence, the applicant must not have spent a total of more than 548 days, so it's there, outside the UK during their qualifying period, where that 548-day total was reached before the 11th of April 2024. And B, been outside the UK for more than 184 days at any one time during their qualifying period where that absence started before the 11th of April 2024. So we've got these two sort of provisions now for new absences post 11th of April 2024. It's 180 days in any 12-month period, but we've got these transitional provisions for absences before, and you're going to have to do the calculation. The guidance gives some examples and have a look at those. But I think if you're making long residence applications for your clients, you need to really allocate time and fee to being able to go through the absences and check that they do qualify. This is an article from LexisNexis News, and the statement of changes also clarified and made some significant changes in terms of going rates in sponsored roles. There were errors in the big statement of changes HC 590 in terms of the going rates. Initially, there was revised guidance that came out on the 10th of July, and then these were finally incorporated into the immigration rules in this statement of changes, HC 217. So I've set this out on the slide and the next slide and the relevant going rates that apply. If you do this kind of work, you probably already know about this, but do have a look at that article from LexisNexis that provides a helpful summary. We're nearly there. Final change of the year was 26 November 2024, HC 334. So Colombia didn't last long on the as a non-visa national country, so they were brought back onto the visa national list. There was an introduction of a new 18-month grant Ukraine permission extension scheme from the 4th of February this year, and a full closure of the Ukraine extension scheme, an end of the use of the PTT letters, and significantly, actually, a change to Appendix long residence that means any leave that your client may have had on the Ukraine schemes will not count towards the 10-year qualifying period for long residence. The justification seems to be, well, we want to support Ukraine. We've always promised people can come back after the war. So they've said, right, we're not going to count any of that time towards Appendix long residence. So here's the parliamentary written statement in terms of Colombia becoming a visa national country, the change to the Ukraine scheme and the new Ukraine permission to extension scheme. And just make sure your clients apply before their current permission expires. The full closure of the Ukraine extension scheme, the end of the use of open-ended permission to travel letters, and here's the summary in terms of the changes to the long residence route to make it clear that permission under the Ukraine schemes do not count. And I've just set out a quick explanatory memorandum. So part one of this webinar is done. We've looked at the 4 immigration rule statement of changes for 2024. In the half an hour left, let's touch upon some case law, and then let's look at some practice direction. So case law, this is my subjective summary of case law. I appreciate there may be other cases that are relevant, but these are some of the key cases that I've spotted and wanted to highlight to you. There's been a battle going on between the Northern Irish courts, spearheaded by the former Upper Tribunal President, now Lord Justice McCluskey, and on the other side, the courts in England and Wales and Scotland in relation to Section 55 best interest points, particularly in relation to the duty under Section 55(3) in the Secretary of State's guidance. The Supreme Court held that the English approach was correct. Effectively, what they've said is, in tribunal hearings, the tribunal is not bound by Section 55. It is the Home Office that are bound by Section 55. In terms of best interests, the obligation to have regard to a child's best interest as a primary consideration in terms of the tribunal stems from Article 8. And in the tribunal, the FTT is the primary decision maker. So the FTT doesn't apply Section 55, but of course must treat the best interests of children as a primary consideration when considering Article 8. And there may, in certain cases, be procedural obligations to make sure those child interests are properly evidenced. Have a look at that in relation to best interest. In terms of Section 55, it still may be relevant in a JR where you're challenging a Secretary of State's decision, where the Secretary of State in the decision hasn't properly considered Section 55. Let's have a look at some European case law. There were these mystery stamps that immigration officers were stamping in extended family members' passports and admitting them to the United Kingdom. In Alarage in 2023, a panel of the upper tribunal held, well, those stamps are not relevant documents for the purposes of Appendix EU, because these guys had been refused them when they applied under Appendix EU, and the refusal doesn't breach the withdrawal agreement. Well, the same issue came in July 2024 before the Court of Appeal. The Court of Appeal took a different approach. They agreed with the approach in the upper tribunal that these documents were not relevant documents for the purposes of Appendix EU, but they found that the stamps, look at the quote highlighted on the slide, in the present appeal, immigration officers decided to admit Mr. Vassar and Mr. Hassanaj to the United Kingdom. That is, they decided to allow them to enter the United Kingdom and reside here with family members who were EU nationals resident in the United Kingdom. Those decisions amounted to the facilitation of residence by the relevant national authority. So those stamps acted as the facilitation of residence. Therefore, on application under the settlement scheme, the Secretary of State was required to accept the stamps in the passports as evidencing the decision to admit the claimants listed to the United Kingdom. The refusal to do so involved a breach of their rights under the withdrawal agreement, Article 18. So they found that the decision to refuse to admit them breached their rights under the withdrawal agreement. A recent decision at the end of last year was in terms of dependency of family members and work. And this overturned a decision of Mr. Justice Lane, the former president of the Upper Tribunal, sitting in the Administrative Court. The appellant in this case had come to the United Kingdom on an EEA family permit when she was 20 years old as the dependent daughter of her Italian mother. She was subsequently granted a residence card. She applied under the EUSS in 2019, by which time she was no longer dependent upon her mother because she'd become estranged from her parents as a result of marriage. The Court of Appeal agreed that the right to work in Article 23 trumped the requirement of continuing dependency. Now, the Secretary of State tried to argue, well, all right, then even if Article 23 does trump Article 7 and the requirement for continuing dependency, there's a causation issue here because she's not dependent because of working, she's not dependent because of being estranged from her mother, but that was rejected by the Court of Appeal. Now, do note the judgment of Lord Justice Green comes first in this decision, but actually he was in the minority. He went further than Lord Justice Underhill, and Lord Justice Singh agreed with Lord Justice Underhill because Lord Justice Green went further, finding at paragraph 111 that dependency must be measured as of the date of the application by the dependent to join the migrant EU worker in the host state. Let's touch upon deportation in a European context, and this has caused a lot of people's heads to hurt. In terms of Abdullah, the Upper Tribunal Judge Rintol in a reported decision, and there's a really comprehensive head note. This is for European nationals who'd been here pre-Brexit, and it's to do with criminality prior to the 11 p.m. on the 31st of December 2020. And the relevant legal regime that would apply to the deportation is set out in the head note. So what you need to do is work through the head note in Abdullah in those sort of cases. In a case called Okafor, the Court of Appeal in January of this year considered what's called the Bushera exception. Now, the Bushera exception is in cases of European deportation. It's normally about future risk, but in the Bushera exception, even where there's not a propensity to commit further offences, if somebody's conduct caused deep public revulsion, they still can be deported. In Okafor, the Court of Appeal upheld the decision of the Upper Tribunal Judge Grubb, finding that the Bushera exception did not apply. But they did agree that the whole different aspects of somebody's conduct could be aggregated when considering whether the Bushera exception applied. The Bushera exception also featured towards the end of 2024 in the Court of Appeal case called George. He had a conviction for manslaughter, but he had that highest level of protection under the EA regulations of imperative grounds of public security. The Upper Tribunal had allowed his appeal. And before the Upper Tribunal, the senior presenting officer had abandoned the Bushera point. So they didn't argue the Bushera point, but they tried to argue it again in the Court of Appeal. Now, the Court of Appeal was split as to whether the Secretary of State could rely on a point that was abandoned below. And I've given you the different approaches from Lady Justice Elizabeth Lang, paragraph 80, and paragraph 92, what Lord Justice Underhill said about that. But they were unanimous that the Secretary of State's point was bad because the imperative grounds of public security is the test to be applied. That doesn't include public policy considerations. So the Bushera exception has no relevance in an imperative grounds case. So the Secretary of State's appeal was rejected. There have been a trio of recent reported cases in terms of deportation and Brexit. The first of those is Vargova. This looks at the legal regime for offences committed after the transition period and the so-called stage 1 decision and stage 2 decisions, both of which have rights of appeal. But the stage 1 decision and the right of appeal there is only really about validity. The substantive consideration, where human rights are considered, etc., look at paragraph 8, is against the stage 2 decision. Magno concerns those individuals who were in prison as of 11 p.m. on the 31st of December 2020. Magno's appeal had been allowed by the FTT on the basis that he was exercising treaty rights before he went to prison for the final months before the end of the transition period. The Upper Tribunal found the judge had erred in that respect, and unless you had a permanent right of residence, if you were in prison at the 31st of December, you were not exercising treaty rights in accordance with Article 7 and were not lawfully resident in the United Kingdom by virtue of the EA regulations immediately before IP completion date. Castro looked at the definition of a deportation order, and this was about conduct committed after the specified date and conduct committed before the specified date. And conduct committed before the specified date, the Secretary of State has to consider then Regulation 27. So the Upper Tribunal added and or before the definition to make sure the Secretary of State, what the Secretary of State was trying to get away with in this case is they were relying on conduct both before and after, but they were just trying to rely on little Roman 1, so they didn't have to use their obligations to consider Regulation 27 and the protections therein. If you've got a case involving conduct before or after, have a look at Castro. Let's change the subject from European deportation to Article 8 deportation. Yalcin, interesting case, appeal allowed by the FTT in respect of somebody who got sentenced to 5 years and 4 months for firearms offences. The judge found that there were very compelling circumstances over and above the exceptions set out in 117C of the 2002 Act, which governs the approach to Article 8 deportation. The Upper Tribunal had set the decision aside, saying, well, the judge had not considered the exceptions when assessing whether there were very compelling circumstances, under 117C6 and had impermissibly downgraded the public interest. Lord Justice Underhill was critical of the determination, which wasn't well written and contained a number of mistakes, etc., but ultimately said that the upper tribunal was wrong to interfere with the decision of the first tier tribunal. And where a tribunal finds explicitly that subsection 6 is satisfied, so that there are very compelling circumstances, they don't need to spell out that the exceptions would be met. And I highlighted what Lord Justice Underhill said there. And what Lord Justice Underhill emphasises, they don't want to make this decision-making in this area more complicated than it already is. And there's a move, as we'll see with the new practice directions, to more simplified, shorter determinations. So I think this is a helpful case if you're trying to uphold an allowed decision. Although I fear probably it'll be used by the Secretary of State where they are trying to uphold a dismissed determination. The Court of Appeal did uphold a dismissed deportation decision in the case of Akhtar. The challenge there was the upper tribunal failed to consider all relevant circumstances when reaching its conclusions under 117C6 on the very compelling circumstances. Lady Justice Elizabeth Lang found that they didn't have to list all those things because they clearly considered all the relevant factors when they did address the exception. In this case, it was a medium offender with the exception applied, and they found the exception weren't met. And similarly, there wasn't very compelling circumstances over and above. Have a look at paragraph 81. I think it's important for practitioners when drafting their skeleton arguments and arguing in a deportation case to set out the factors that are relied upon when trying to argue that 117C6 and very compelling circumstances are met. Let's stay with Article 8 and look at the question of limbo. AM Belarus, very sad case in reality. Belarusian national came in 1998 and claimed asylum. Deported to Belarus in 2001, but he said he was not, he told the Belarusians he wasn't Belarusian. He was returned to the UK. They haven't been able to get travel documents for him. He's now been convicted of a number of offences, mental ill health, psychotic symptoms, his mental health adversely affected by the delays. A presidential panel, when Mr. Justice Lane was president, found in AM that the failure to grant him leave and keeping him in limbo breached Article 8. The Supreme Court disagreed and found that the upper tribunal had failed to give proper weight to the deliberate actions of AM in contributing to the fact that he was in limbo. And also the upper tribunal had erred in the strength of the public interest against AM. So the Supreme Court determined it for himself and found that it wasn't a breach of Article 8 to keep AM in limbo. So this makes it much more difficult to get leave in limbo cases. There's been a couple of cases about fairness, judges and fairness in 2024. Hussein was an ETS case where the judge asked a load of questions after each witness had given evidence. Lord Justice Moylan said the question of whether a hearing is unfair is an objective assessment and is context and fact specific. And looking at this case, they held that the judge had not been unfair because she'd waited until after cross-examination to ask her questions and gave counsel an opportunity. One thing the Court of Appeal did stress at paragraph 79 is the duty on counsel to raise unfairness during the course of a hearing. So put on your crash helmet and you need to challenge the judge if you think they're going too far and descending into the arena. The fairness challenge in the case of Hema was successful in the Court of Appeal. This was a marriage of convenience allegation. Lord Justice William Davis again summarises the objective assessment in terms of fairness. And Lord Justice Underhill set out how in this case the judge had acted unfair for 3 reasons, asking questions that went beyond clarification and amounted to cross-examination, basing conclusion his conclusion on something that hadn't been raised with the appellant or his representative, and actually was contrary to a previous tribunal finding, and also making unfounded, inappropriate criticisms of the representative in that case. Although Justice Underhill says he doesn't want to discourage judges from asking relevant questions, but obviously what it's appropriate depends on the circumstances of the case, and the judge should never compromise the fairness of proceedings or give an impression of partiality. Really helpful clarification case in Al Hassan about Article 8 in entry clearance. The problem with the previous case of KF is sometimes judges would focus only on the rights of the sponsor and really exclude the rights of an appellant in an Article 8 entry clearance. This was a family reunion case. Upper Tribunal Judge Rintol, in this reported decision, relying on the case of Abbas in the Court of Appeal, brings a more helpful position. With due respect to the panel, while the rights of the person or persons in the United Kingdom may well be a starting point, and that there must be an intensive fact-sensitive exercise to decide whether there would be a disproportionate interference. We do not accept that it is correct law to focus exclusively on the sponsor's rights. To do so risks a failure properly to focus on the family unit as a whole and the rights of all those concerned. It also is to be borne in mind that it's the appellant's rights which are an issue in these appeals, not the sponsors, given the terms of the grounds of appeal, something the panel in KF Syria appears to have overlooked. I said lots of ink had been spilt on the old long residence rules. In Upper Tribunal Judge Mandalia, in a judicial review, found that you couldn't rely as lawful residents leave that had been obtained previously by deception. Just because of time, I'm just going to summarise quickly in that. The Ramphel case was a great success in front of Mr. Justice Kavanagh in terms of obtaining digital proof of Section 3C leave. That's been appealed to the Court of Appeal. Permission has been granted. There's a stay on things. Have a look at the Ramphel website. There's a really helpful article on there summarising the position and also giving a template letter if on an individual case you need to apply for digital proof of your Section 3C status for your client. So have a look on the Ramphel website in relation to that. If you're challenging civil penalties, and I think we've seen an uptick in these sort of things, have a look at the Akbar's case. Akbar's tried to say the notice wasn't compliant because it just listed all the statutory reasons, and that was a fatal defect. Lord Justice Zaccaroli had no hesitation rejecting that argument. They also give guidance as to the approach on appeals in a civil penalties case, so have a look at that. Plenty of sponsor license challenges. There was that thread of cases about whether a global assessment was needed. Supporting care said yes, but they hadn't taken into account Presswick. New Hope was successful on the fact that the Secretary of State hadn't given the claimant the appropriate 20 days to respond to the Secretary of State's concerns. But in terms of the global assessment point, in New Hope, they followed Presswick and rejected that argument. Similarly, in One Trees, they followed Presswick and rejected the global assessment approach. Tendercare is an interesting case. Effectively, they were acting as an employment agency, providing care workers to other care homes. It's impermissible for a sponsor to provide workers to third parties. This is a helpful case in terms of the judge providing a summary of the sponsor license regime, what the role the court will take in a judicial review and the principle of fairness. This mandatory breach, they found there was no discretion in respect of mandatory breaches. There had been some additional discretionary grounds for revocation, but there's no need for a separate analysis of those where there is a mandatory breach. Time limits for appealing. Chowdhury's a helpful case. Chowdhury was an EEA refusal where the Secretary of State wrongly said there was no right of appeal. To be fair to the Secretary of State, actually, they'd relied on that upper tribunal case of Salah that was subsequently overturned by the Court of Appeal in Caen. In 2022, Mr. Chowdhury lodged a notice of appeal. The Court of Appeal said because the notice was defective, time had not begun to run against him. and that his appeal was in time. And the case of Mir Pali was dealing with a different issue. Helpful decision there. If you're challenging electronic monitoring, have a look at the decision of the Upper Tribunal in Nelson, finding that there had been breaches there. Poor guy, the tag hadn't been working for about 6 months at the time he came to court, and some very comprehensive guidance, including the approach to the gathering of trail data in the case of ADL and the decision there of Mr. Justice Lavender. Deprivation of citizenship, we've already seen movement in respect to that in case law at the beginning of 2025. I'll cover that in other updates. Ulla concerns dishonesty, looks at the approach of the Supreme Court in Toohey and Griffiths and the need for the Secretary of State to cross-examine on these points. The test of dishonesty is that set out in Ivey. They restore the decision of the FTT, allowing the decision, and found the Upper Tribunal were wrong to treat it as a decisive factor that the appellant had pleaded guilty, even though he then ticked the box in a criminal offence, even though he ticked the box then that he was of good character because of the nature of the mens rea in the criminal offence he committed. Have a look at that. Been quite a bit of case law on in asylum cases on surplus activity and Facebook posts, particularly in the context of Iran. But I think following the Upper Tribunal judgment in XX from a few years ago, this is relevant across the board because a lot of cases now we see surplus activity and social media, particularly Facebook activity. FA Iran was successful by the appellant. S wasn't. And there's guidance there in terms of deleting Facebook accounts and how judges are to deal with surplus activity. So have a look at those. We're now dealing with cases where NABA applies protection cases, and we've got the variable standard of proof from section 32, 5 questions effectively in a protection claim under NABA. Is it a convention reason? That's the balance of probabilities. Is it a subjective fear? That's the balance of probabilities. In terms of risk of harm, state protection, internal flight, they're the lower standard of proof. I think I've included the paragraph where helpfully Upper Tribunal Judge Bruce looks at the subjective test and the discrete exercise of assessing that fear as to whether past events had occurred and the relevance of credibility. So have a look at paragraph 17. SM is about the revocation of protection status post-Brexit. If you're dealing with a revocation of protection status, go through the guidance set out in SM. And Azizi is about succinct credibility findings. And this is actually a bridge to the third part of the webinar, because we're seeing now more succinct determinations. A judge can deal with controversial issues very succinctly, but they must, if an appellant has told lies, deal with the explanation for telling those lies in their decision. So that takes us finally in the last 6 minutes to practice and procedure. But my next webinar coming up, have a look at my links, is going to deal with the new practice directions in depth. So have a look at those specifically. But we've got the new practice direction from the 1st of November 2024. Big themes: procedural rigor, disputed issues. Don't forget all your documents, 12-point text size, no less than 1.5 line spacing. That applies to everything. There's your requirement for digital bundles, indexed, bookmarked, hyperlinked, optical character recognition. Make sure you're doing that. Your ASA shouldn't be more than 12 pages, or you need to make an application. Don't include in your bundle anything that is in the Home Office bundle. A respondent's review shouldn't exceed 6 pages. It shouldn't be pro forma paragraphs. The respondent should set out if they agree with the schedule of issues, identify which witnesses they want to challenge. Look at post-review evidence. If you're putting in further evidence, you need to seek permission. Don't resubmit a whole bundle that contains the whole thing plus the new evidence. Just do an addendum bundle with the additional evidence. Otherwise, you're going to get this stitched bundle, which will make your judge mad with loads of repetition in it. Witness statements need to be complete, because 8.4, only with good reason and with the permission of a judge will you be allowed to ask questions in evidence in chief. That is a slight relaxation from the previous exceptional grounds for asking questions in chief. There are clear guidance on the body of a witness statement. So in terms of your pro formas on your computers in your office, make sure your pro formas for witness statements follow the requirements of the practice direction, particularly the statement of truth and what's need to be said by the interpreter. This is now clarified. What we thought previously is you had to get the whole you write the witness statement in the client's own language and translate the whole thing. We don't have to do that now, and there's clear guidance. So any interpreters watching, have a look at the requirement for the interpreter attestation. Expert reports need to be focused and not exceed 20 pages, and you need to make an application if it's going to exceed 20 pages. I've skipped out 9.3. I'm going to cover that in another webinar dealing with the actual requirements for expert reports. They shouldn't exceed 20 pages. The President, Judge Plimmer, has done a letter giving some further guidance on this issue. Now, country background information. You don't just chuck in loads of pages of country reports, but there needs to be a country background schedule, no more than 12 pages with hyperlinks to the source documents. And you can, if you're challenging something the Home Office says in their refusal letter, you can ask them to produce the whole country report. And similarly, they can do that with you. And we are seeing a reduction in the written reasons given. This is the senior president's practice direction on the giving of written reasons, which sets that out. We've seen a presidential guidance note number 2 of 2024 in terms of the procedure on giving evidence from abroad. You need to check the FCDO website for the list, because if it says no, your client can't give evidence from abroad, or your witness can't do it, the tribunal have no choice in those circumstances. If it says yes, you still have to make an application to the tribunal. Or there may be cases where they say, well, it's a specific permission case by case in which you make an application and you may need to pay an extra fee to the FCDO, but that's all set out there. And still the tribunal can refuse where it's going to lead to excessive delay, and they've got to consider the overriding objective. Just finally, appointment of litigation friends in the tribunal. There's no specific procedure rules, but now there's some joint presidential guidance. It's different to vulnerability. If you've got a vulnerable witness, make provision for that vulnerable witness and reasonable adjustments. But if your client lacks capacity, then you need a litigation friend. And that's usually children who are not capable of conducting or giving instructions. That's not all children, because some children will be able to do it. And an adult who lacks capacity. I've only put sections of the presidential guidance, and I'll deal with this in another webinar, but I've set out about the official solicitor there, paragraph 30 and 32, the procedure you need to follow. Again, here's my link to upcoming resources and upcoming seminars. Do sign up to everything. I've just set up a new WhatsApp channel where I'm trying to put updates for free on WhatsApp, but there's 1 minute to go, so I think I should hand back over to Finn. Thank you very much. It's been a pleasure. Thank you for joining today.
Yeah, thank you so much, Adam. Appreciate that. And thank you everyone for joining us today. I apologise again, but we can't answer any of your questions due to time restraints. As a reminder, the slides and a recording of the webinar will be sent over tomorrow. This afternoon, you should receive an email asking for you to rate the webinar out of 5 stars. If you've enjoyed the webinar today, please do leave feedback and any suggestions for future topics. Our next free webinar is on Tuesday, the 11th of February, when we will be presenting a webinar on cyber essentials for law firms, achieving compliance and protecting your business against cyber threats, presented by Tyrone Reibenheimer, who is the Head of Security and Cloud Technologies at Sharp UK, and Simon Jeffries, who is the Director of Technology at Sharp UK. Thank you again for watching, everyone, and take care. Have a good afternoon.
Thanks, everyone.
Cheers. Thank you, Adam.